We are here today on the state's suit for modification of child support obligation. Both parties are present. Your Honor, the both parties were present before the court, and we did a temporary order on August 20th, 2025, at which time all issues were addressed in the modification order. And the state and the father, the custodial parent, Mr.
What happens when child support jumps nearly double overnight, and the parent ordered to pay says it's pushing them to the financial edge? Today's courtroom showdown is packed with high stakes, emotional testimony, and a hard judicial line that refuses to bend. One parent says the math doesn't work. The other says the child comes first. And the judge? She's about to make it clear why fair doesn't always mean flexible. Stay with us, because this ruling hits harder than most people expect.
Epperson are asking that the court make those terms final, Judge. And Ms. Greer is asking for a downward deviation as to child support today. Your Honor, I'd like to call Mr. Epperson first.
You may.
Thank you. Mr. Epperson, what is your full name?
Anthony Epperson.
And Mr. Epperson, you were present before the court on August 20th, 2025, at which time a temporary order was signed. Is that correct?
That's correct.
Okay, and there is one child before the court who lives with you, correct?
Yes.
And you're asking that the terms of the temporary order be made final today.
Yes.
And basically, and as such, you're asking that the court order that Ms. Greer continue to pay child support of $600, excuse me, get that, of $697, correct?
That's correct.
Okay, and you're still in agreement to continue to pay or to provide the private health and private dental coverage for the child, correct?
That's correct.
Okay, and you believe that making the terms in the temporary order final are in the best interest of your child, correct?
Yes, I do.
And do you have any safety concerns, new safety concerns in the case since the terms of the temporary order?
No.
Your Honor, I'll pass the witness and call the mother.
You may.
Thank you. Ms. Greer, what is your full name?
Jennifer Greer.
Ms. Greer, you are in agreement to all of the terms of the temporary order being made final except for the $697 child support amount, correct?
Correct.
Okay. Are you currently employed?
Yes.
Where do you work?
Claire's.
One more time, please.
Claire's.
What kind of company is that?
That's retail.
Okay. And what's your job title?
Store manager.
Do you get paid hourly or do you get paid a salary?
Hourly.
And what's your hourly rate?
24.
How many hours a week do you typically work?
40.
Do you have any other biological minor children other than?
I have one. He's 18.
Does that child live with you?
Yes.
And has your wage income changed since we were here for the temporary order?
No.
Okay. And you understand the state is asking that the $697 amount be made final today, correct?
Yes.
And you are asking for a different number?
Yes.
What number are you asking the court to set your child support at today?
The original amount I was paying was $375.
You're referring to the amount ordered in the 2019 order, correct?
Correct.
Okay. And why are you asking that?
This is the moment a lot of parents watching will recognize immediately. Miss Greer isn't denying responsibility. She's arguing survival. Rent, 2 car notes, and a support increase from $375 to $697 is not a small jump. But here's the legal reality. Financial strain alone usually isn't enough for a downward deviation. Courts focus on income, guidelines, and the child's needs, not prior arrears, not past sacrifices, and not whether the increase feels overwhelming. The question becomes, should personal hardship ever outweigh statutory guidelines when a child's welfare is on the line?
The court order a downward deviation today.
Well, first, because the new amount, it's preventing me from being able to pay all of my bills right now. I have rent to pay, I have 2 car notes I'm paying, and I just can't afford that amount. Secondly, I was asking for it to be like hold off because I did file for an administrative review, because originally I was the one who
I'm going to
filed.
object to relevance, Judge.
Okay.
Objection sustained. Go ahead, Ms. Greer. Is there any other reason that you're asking that that I deviate from guidelines?
I requested an administrative review because originally I filed for child support.
Objection, relevance.
Okay, ma'am, go ahead. I'm gonna let it come in. Go ahead. You filed for child support and what?
Yes, I filed for child support in 2019. Originally he was paying, and before everything was switched over, none of the arrears that he owed was ever addressed. So I did request a review for the arrears. Because from 2009 to 2019, I took care of my son by myself financially. Before everything was switched over, I received a default.
Ms. Greer, you do
Mhm.
understand that what he owed you in arrears does not have any effect on what you should pay going forward, correct?
Okay, I understand.
Okay.
But can I say that the amount that I'm paying, it's preventing me from being able to pay my rent and my car note. I've gotten behind on my car note now. I can't afford to pay him that amount of money and still keep up with my bills, because my bills were set around what I was paying before it was increased.
Okay. Anything else?
That's it.
Does your son that live with you, is he still in high school or has he graduated?
He's graduated.
Okay, so he's technically not a minor anymore.
No, he's not a minor, but he's not
Okay.
in school or anything.
Okay. Anything else, Mr. Dale?
Nothing from the state, Judge.
Okay. Anything else either one of you want to tell me?
No, Your Honor.
Okay. Then I will accept the agreed portions, make the terms of the temporary order final, and I will order that mom pay guideline child support of $697 a month. Do either one of you have any questions?
No, Your Honor.
Okay, now that I've made my ruling, I'm not the last word on this. If you don't like it, if you think it's not fair, if you don't agree, you have 3 days to appeal, 30 days to file a motion for new trial. Mr. Dell, what court is this out of?
The 303rd.
This is out of the 303rd District Court. That's Judge Laditra Atkins. She might have a different opinion from mine. Do either one of you have any questions now?
No, Your Honor.
Okay, then thank you both for appearing here today, and you're both free to go.
We're here on the state's motion to modify support and confirm arrears. Judge, all issues are agreed to except for the child support. Parties are requesting a deviation. If I could read the terms of the proposed order and then take testimony.
You may.
Thank you, Judge. Parties are agreeing to a child support judgment after possession credits and release of $0. That would be as of November 4th, 2025. Judge, there are no medical arrears or dental arrears owed on the case. Judge, as far as the modification, Judge, the modification would be for the child support review order previously done on December 23rd, 2024. Judge, this order going forward would maintain that Mr. Daly provides the medical insurance. He has that available through TRICARE. Judge, the calculation of the child support would modify his child support to $382. Judge, he was previously ordered to pay $352. The state's position was that it would not be right for a modification, since it's a $30 difference. However, parties are both requesting $0 for child support. So that's the issue going forward. Court costs would be as billed to Mr. Daly, and neither party is requesting any non-disclosures of their addresses.
Okay, you may call your first witness.
I'll call the mother. Ms. Knight, did you hear the terms of the order as far as the judgment on the child support arrears?
Yes, I did hear.
And Mr. Daly previously had possession of y'all's son for 2 years, is that right?
From 2023 to 2025, yes.
And so you understand and agree to that child support judgment of $0 after he's given those credits?
Yes, ma'am.
And you agree that Mr. Daly will continue to provide the health insurance for y'all's son?
Absolutely, yes.
Okay. Now, as far as the child support going forward, you're requesting that he not be ordered to pay any child support, is that right?
Yes. Well, the child support is less than what he helps me with now, so I feel like it's better for us to just communicate with each other.
And when you say less, you mean the court-ordered child support, the
Yes.
$352 is less than what he pays you?
Yeah, what he gives me.
Okay. So how much money does he give you a month?
My son has dental and he does athletics, so he pays for like whatever shoes or fees that they have, and he also pays for his braces or if anything that I need, groceries. So
Is there-
around it might be $600 if I need
Okay.
more.
And so it's, other than that, is there anything else you want the court to know as far as your request to deviate?
No, I just feel like I'll get more help outside of child support. So,
Do you have safety concerns with your address or contact information being listed in the court order?
no, I don't.
I'll pass the witness, Judge.
You may call your next witness.
I'll recall Mr. Daly. Mr. Daly, you understand and agree to the child support judgment after your possession credits of $0 today?
Right.
And you're in agreement to continue to provide the medical insurance for your son?
Yes.
And you also understand that the child support amount will be $352 a month, but you disagree with that?
Yes. Because I would like it to be $0, but yes, I'm sorry.
Can you tell the court why you're requesting it be $0?
Because just to verify exactly what she's saying is that before we even got to the situation that we are today, my son was living with me for 2023 until July 8th of this year, that he's back in Dallas. It's just something that me and her has agreed on, and we try to get to this point before. And every time we get to this point, the arrears, and then we have to speak to another judge, and we keep going back and back and back because we keep trying to get the same system done. If, like she said before, I reiterate, if I just did the $352, I give her $600 a month already, and anything she needs, I'm gonna give it to her because my son, I love him dearly. And if I just gave her $352, it's less that I would give her anyways. So that's one of the main reasons. And we don't need the government to interfere, to be honest with you, because we have a great relationship. I know how some people like, oh, it may change, things change, that's life, period. But we are adults and we have grown even more to handle this. We've been trying to do this over 2 years, but keep getting the same results. We keep getting the same results, rear and then back here. So we just want to get done with it because we have the mindset, the ideology of a grown person to get it done. We have been doing it.
Okay. Do you have any safety concerns with your information being listed, Mr. Daly?
No, not at all.
I'll pass the witness, Judge.
Okay. I understand everything that the two of you just told me. I even believe that it's true. But I'm still gonna leave the child support at $352. Mr. Daly, just send her the other $300. It's already there. You just need, if you're giving us $600, just pay the difference. Or ma'am, if you don't want the money, send it back to him. I'm going to order the child support to safeguard your child's rights. I understand that you guys are working things out. It's very commendable.
This right here is the judge pulling back the curtain on how family courts really operate. Even when both parents are cooperating, even when extra money is already changing hands, the court still locks in guideline support. Why? Because agreements can fall apart, memories fade, and future disputes need a paper trail. This isn't about mistrust, it's about protecting the child's rights long term. So here's the question for you. Should courts honor cooperative parenting agreements, or is this kind of legal safeguard absolutely necessary when emotions and finances collide?
I applaud you for it, but my job is to do what's in the best interest of your child. And what I think is in the best interest of your child is for you to pay the $352 a month. Ma'am, if you don't want it, if you don't need it, put it in a savings account for him. Like I said, give it back to Mr. Daly. That's fine. But if you come back in a couple of years because things have fallen apart or because you want more money, you won't be able to prove, it'll be hard to prove a change of circumstance. And that's why I always order the child support. It's not because you guys aren't working together now. It's because, like he said, we don't know what'll happen in the future. You might continue to work together. You might not. I don't know. So I'm going to do what I think is in the best interest of your child. Now that I've made that decision, I'm not the last word on this. You have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 303rd District Court. That's Judge Laditra Atkins. She might have a different opinion from mine. Now that I've given you that information, do either of you have any questions?
I do, of
Yes,
course.
sir.
Can I waive the fees for the court if that's something you would do as well? Because we've been trying to do this for a while, and I think in November, October, we tried to get this going, and they canceled without notifying us, and that's why we're here today. Because they canceled without notifying us.
Okay, if you still had possession of the child, I would waive them, but I don't have a reason to waive them right now.
Okay.
The court fees are not, that's not something you pay to the attorney general. That's what you pay to the court. So if they canceled your hearing, that's on them. That's something you need to speak to them about, okay?
Yeah, when we tried, Judge, we tried so many times. She even went to, when my son was with me, she went to the Dallas child support, and they gave her the runaround. She went there, filed the paperwork, and all that. But I'm just gonna get a lawyer. That's fine. I know how to
But for the period of time that your child was with you, we've given you relief. That's why you don't have a judgment.
Yeah, that's true.
Okay.
Okay, great.
All right. Any other questions, sir?
How do we file appeal? And
The Attorney General's office can email you if they have your correct email. They can email you the instructions on the appeal, sir.
Okay, that's fine.
Do I
Anything
need
else?
to appeal as well?
Excuse me?
Do I need to appeal as well?
That would be up to you, ma'am.
Okay. Thank
Okay.
you.
All right. Now, if there are no further questions, thank you both for appearing here. Good luck to both of you, and you are both free to go.
This was an agreed CSRP that was submitted to the court for review, and I believe the court requested that to be set for a hearing due to the order containing a deviation from guideline child support. I'll just inform the court that the guideline amount would be $595. The agreed upon,
$595?
yes, Judge. The
Okay.
agreed upon amount was $400 for the deviation, and then I'd inform the court that we're asking that it be as amended, whether the child support will change or not, just so that the start date can reflect December 1st. But if I could take testimony from the parties on the issue of the child support.
You may.
I'll call the father. Sir, would you please state your full name?
Alexis Camargo.
And you understand that the guideline calculation for your child support based on your income is $595, correct?
Yes, sir, correct.
And you are asking that the court deviate in order that that be $400. Is that correct?
Yes, sir.
What is the reason for that?
Well, first, I do get him 3 times a week. So I do have him some time for me. And also I do have a lot of bills. I have truck payment, rent, everything. So we agreed to 400 because we assumed that was comfortable for both of us, for both parties, me and Ashley Casorena. But since we're here and I heard about the 595, so we're gonna try to get that figured out.
Is there any other reason that you're requesting the deviation?
Well, no, sir.
I'll pass the witness, Judge.
Okay, you may call your next witness.
I'll call the mother. Ma'am, would you please state your full name?
Ashley Castrena.
And you are also requesting that the child support deviate from the guideline amount. Is that correct?
Yes.
And is there any reason other than what Mr. Camargo stated that you're making that request?
No. That'd be the same reason.
I'll pass the witness, Judge. Just ask for a ruling on the issue of the child support.
Okay. Then I will order guideline child support of $595 a month. Ma'am, if you don't need it, if you don't want it, you can give it back to him. I'm charged with I'm charged with doing what's in the best interest of your son. If you deviate from the guideline amount and you come back later, if he stops getting him for 3 days and you're mad about that, if you come back, I won't know what you agreed to. I won't know what changed. And so it's hard to prove a change of circumstance. So I like to order guideline child support so that you can always prove a change. And that way, if you want to give it back to him, if you want to put it in a savings account for your child, you can do that. But I am going to order the $595, okay?
Okay.
Do either one of you have any questions?
No, ma'am.
Okay, now that I've made my ruling, I'm not the last word on this. If you don't agree with it, if you think it's not fair, or you just don't like it, you have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 256th District Court. That is Judge Sandra Street. She might have a different opinion from mine. Now that I've given you that information, do you have any questions?
No, ma'am.
No, ma'am.
Okay, Mr. Tallien, the new start date will be December 1st.
Thank you, Judge.
Okay.
In the end, the court stayed firm, ordering full guideline child support across multiple cases, regardless of agreements, hardship claims, or good faith cooperation between parents. The takeaway is clear. Family courts prioritize consistency, documentation, and the child's long-term protection over short-term flexibility. Whether you agree or disagree, these rulings highlight how rigid and intentional the system can be. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Okay, if there are no questions, thank you both for appearing here today, and you're both free to go.
Thank you.
Mhm.